I would like to very warmly welcome you to this webinar today. It is the second webinar in a series organized by the legal chapter of the Swiss Chinese Chamber of Commerce. We have again topical issues on the COVID crisis. We will try to follow up throughout the summer, after the summer holidays, with our third event. And today is the last event before the summer break. So we have two topical issues. One is the duties of the board of directors during the COVID-19 crisis. Are there any different from the other duties that you have during your normal times in life, so to say? The other one is debt enforcement and bankruptcy after the COVID-19 period. We've seen that many companies these days have some difficulties. We have heard of companies closing down, of changes. So this is a crucial time for board members in terms of how they go about this particular situation, and if need be, if they need to look at their liquidity, debt enforcement, and so on. Before we start, I would like to do a few logistical remarks, to give you some logistical remarks. I have to remind you that the session is recorded so that everyone knows that. There is a chat function, and I really welcome you to use the chat function and to put your questions there. You can ask questions to either of our speakers. We will take the questions after the two separate topics today. Please say to which speaker your question goes. So we will try to follow up. Of course, we can take any questions after the two sessions as well. So to follow on, our first topic is, as I mentioned, the duties of the board of directors during the COVID period. Are there any different from the normal duties of the board? We have our speaker here. This is Lukas Zuest from Vischer AG. He's a senior associate. He is the head of the China desk of Vischer, and he spent many years working in China and brought back all his experience to Zurich, now working with the Zurich office. Our second and third shouldn't really make a sort of a row, but those two come from Meyerlustenberger Lachenal. We have Florian Müller, also senior associate with Meyerlustenberger Lachenal. He's the head of their China desk. And we have his colleague here, May-Si Hau, also from Meyerlustenberger Lachenal. Obviously, she's from China. She's a Chinese lawyer with many years of experience. So I'm very happy to have the team here on board. And I would like Lukas Zuest to start first with his presentation on the duties of the board of directors. So Lukas, please, the floor is yours.
Thank you very much, Esther. I quickly share my presentation with you. Esther, do you see my presentation right now?
I see it, so I think everyone sees it. It looks very nice, very beautiful, colored.
Very good. It's a picture from the Rist.
Okay.
Thank you very much, Esther, for your kind introduction. The duties of the board of directors during the COVID-19 crisis, are they different than in any other crisis? This is the question that I would like to pursue in the next 20 to 25 minutes. I will first get into the question, what are actually the duties of the board of directors outside of a crisis, just as such. What is the board of directors? What are his duties? Then in the second point, I would like to go into the question, what happens, how do the duties shift, or how does the duties have to, on which issues does the board of directors has to focus if a crisis arises. Then in a third point, I would like to go into the details, what is different in this current COVID-19 crisis than in another crisis, in previous crises. And in a fourth point, I would like to take a special look into the matter where the board of directors of a Swiss subsidiary of a whole group, could be a foreign group, but could also be within Switzerland a group, what special considerations the board of directors has to take in this regard. And then as a last point, I would like to discuss with you what are actually the consequences if the board of director breaches its duties. So going to the first point, what are the duties of a Swiss company's board of directors? As such, the board of directors can actually organize itself very freedomly. It has a lot of freedom how a board of directors wants to organize himself. It can delegate certain matters, certain competencies and responsibilities to individual members of the board of directors, or it can also delegate some parts to a management of a company. That all depends on the size of the company. However, there are certain duties that the board of directors cannot transfer. They are non-transferable and inalienable. As such, I will not go into all of the duties that are not transferable, but as a general rule, the overall management of the company and the overall strategic management and the overall financial management of a board of directors cannot be transferred by the board of directors to only an individual or to a board of management of the company. In this regard, and since we have the topic of a crisis, a very important responsibility and very important regulations in this regard are the capital protection rules. Capital protection rules are set in order to protect mainly creditors, but also the whole company as such. There are twofold, the capital protection rules that we have in Switzerland. First of it is if the last balance sheet that the company has issued actually shows that the half of the company's registered capital, including the distributable reserves, if they are not covered by the assets of the company anymore, that means that it's not over-indebted yet, the company, but it's between a well-operational or a well-solid company and an over-indebted company. If this occurs, then the board of directors immediately has to convene a shareholders meeting and has to suggest restructuring measures. The second point is if the board of directors has reason to assume or believes or sees indices that the company could be over-indebted, it has to draw immediately an interim balance sheet. It has to draw immediately an interim balance sheet, and this balance sheet has to be drawn as a going concern, on a going concern basis, but also on a liquidation basis. And this interim balance sheet then has to be audited by the company's auditors. If then this interim balance sheet shows that the company actually is over-indebted, the board of directors has to take immediate actions, and it either has to seek for new capital so that the shareholders contribute new capital, recapitalize the company, or it has to ask the creditors of the company to subordinate their claims. If this is not possible, if neither of this is possible, the board of directors has the duty to file for bankruptcy of the company or to ask for a moratorium. We will later on come back to those specific capital protection rules with regard to the current situation. Then another duty is the duty of care. A director within a company must only assume the position as a director if he or she is actually suitable for it, if he or she has the relevant experience. And that always depends on the size and of the business of the company. And then another point which is important is the duty of loyalty. The board of directors always has to always has to act in the best interest of the company. So when a crisis happens, when there is a crisis, the business as usual cannot be continued. Then also the role of the board of director also has to adjust its role. Usually, if you have business as usual and you have a good good operations, then you meet like 4 times a year, for instance. You have board meetings once a quarter. But if a crisis occurs and and is immediately here, then the board of director has to show leadership. It has to adjust to the specific situation immediately. It has to be available, timely, and it has to meet as often as the situation requires. So this is very important that the board of director, even if it has delegated in normal times the management to a management board, to a CEO, etc., in times of crisis, the board of director has to assume leadership. And obviously, there are 2 very important matters that the board has to focus on. It has to focus on liquidity management. It has to see how costs can be reduced. So that those obligations that the company has to meet can be met. We have seen it in this crisis in particular, where the income all of a sudden stops. You have to seek a reduction of costs, for instance, with reduction of a short time work, the reduction of the work time of your employees. So you can apply for short time work, so that you don't have to bear the salary or only part of the salary of the employees, depending on the specific case of your company, or ask for emergency credits. Then over-indebtedness risk, it is very important, and coming back to the capital protection rules, this is important that you keep track, that the board of director immediately understands where the company is, if there is an over-indebtedness risk present. Then just as a general comment, the board in a crisis, the worst the board can do is just stay inactive. Believe, okay, the management that just continues, we see what it does. This is probably the worst the board can do. In the times of crisis, the board has to become active, it has to be involved, it has to take decisions, communicate also with the stakeholders, and decide what actions have to be taken. Even if retrospectively in the past it shows that one of a decision was wrong, when you look back at it, when you took the decision, if the board was actually well informed and the board the decision of the board was reasonable at that time when the board took the decision, then the board actually doesn't have to fear or be to fear any being held liable. And last but not least, proactive information. It is important that the company proactively informs all its stakeholders, the shareholders, the employees, but also creditors and business partners. So what is different in the current crisis, in the current COVID-19 crisis? Well, we've all gone through that in Switzerland since mid of March with the lockdown. The impact and the magnitude was overwhelming, was huge. That's for sure. What is different in this specific crisis is that the Swiss Federal Council, as most of you already also know, has then issued emergency legislation. And this emergency legislation also has impact in the end on the duties of the board of directors. One example was, or still is, it's not as imminent anymore because we can now meet again, but having once a year you have the annual general meeting within the company, and that typically is held physically, also according to the law. So the Swiss Federal Council issued or decided in this emergency legislation that the general meetings of a company actually can be held also either electronically or in writing. And this was possible in an initial step. It was decided that this is possible until the end of June of this year. Just 3 days ago, the Federal Council decided to give this possibility even until the end of August of this year. Over-indebtedness. So coming back to the capital protection rules, the Federal Council also issued, or the ordinance that the Federal Council issued is also relevant with the over-indebtedness. It says that, or the problem that the Federal Council saw is that actually companies who were before the crisis solid, were on a good basis, had a good business model, but all of a sudden faced all those issues, lack of revenues, etc. So that these companies who at the end of last year were actually sound, were not over-indebted, but now suffer from the crisis, but believe that by the end of this year, they can actually get back and have a prospect of restructuring, that these companies, even if they are now over-indebted, do not have to file for bankruptcy. So this is also an impact from the Swiss Federal Council's decisions, legislation on the duty of the board of directors. The Federal Council also introduced other COVID-19 related insolvency measures. I will leave that to Florian and May-Si. Later on, they will also touch the COVID-19 moratorium, which handles liquidity issue. There is another point that I think is important also to mention, in particular to companies that are part of a group, a Swiss subsidiary belonging to a Swiss group or a foreign group, a Chinese group of companies. What's important to consider here is we have two different sets of interests. We have on one hand the interest of the company. So as I mentioned in the beginning, the board of directors always has to act in the best interest of the company. But if a company is part of a whole group, we also have the group interest. And this is then, these two interests can be contradictory, and there we can have a group dilemma. In particular, there are particularly two points where this group dilemma may occur. In one possibility is if you have upstream loans and side stream loans. An upstream loan means that the Swiss subsidiary grants a loan to its parent company, and the side stream loan means that the Swiss subsidiary grants or gives a loan to one of its affiliates. Cash pooling is also something where such group dilemmas can occur. Cash pooling is a measure how you do usually once a day. You take all the liquidity and put it into one cash pool leader company. We will not go into the details of a cash pooling arrangement at this stage, but this is also something where the group dilemma may occur. So coming back to the COVID-19 crisis, what does that mean in particular with regard to loans, upstream loans given to the parent or side stream loans given to an affiliate? It means that if now during the COVID-19 crisis you give a loan to the parent company that is not at arm's length. At arm's length means that it's not at the same conditions as if you would give it to a third party which is not related to you, then the board of director has a problem and could violate its duty, its loyalty duty. So if you now give during this crisis a loan upstream or side stream, you must provide it either secured, there has to be a security, or the company can only give it to the extent that the loan is actually covered by the freely distributable capital reserves. Another point which is very often also discussed, and we've been also asked in our practice, well, within the group, we have the parent company. Can the subsidiary actually rely on the parent company? Must the parent company help the Swiss subsidiary or the subsidiary here in Switzerland? And the answer is no. From a legal perspective, the shareholder doesn't have such an obligation to come and help and the Swiss subsidiary. It only has to help the Swiss subsidiary if it has a binding commitment, if there is actually a real binding commitment by the parent company, but not according to law. Coming to the last point, well, what actually are the consequences if the board of directors then violates its duties, its obligations? Well, first and then most importantly, there is a civil liability. The individual board member may become personally liable towards the company, towards the shareholders, or towards the creditors if it breaches its duties, its obligations towards the company, either intentionally or by negligence. And what is important to mention is that towards the creditors, it only then becomes liable if the company actually goes bankrupt. Then it can also become criminally liable. In particular, what is important here in this sense is that for mismanagement, actually, if it intentionally breaches its duties. So what are the key takeaways I would like to give to you is that if a crisis occurs, a huge crisis like the COVID-19 crisis, that the board must show leadership. It must become active, must focus on liquidity and potential over-indebtedness risks. The actions that you take, they should be on an informed basis. And what is important for the board of directors that retrospectively, in case potential claims will be submitted, that you can also show as a board that you have taken those decisions based on an informed basis. And that is important that you record. The board of directors actually records its actions taken or its decision taken, and always act in the best interest of the company. With that, I would like to close my part, and if you have any questions, feel free to raise them.
Thank you very much, Lukas. I don't see any questions so far. Maybe I start with one question. Maybe people will come in then with other questions. You said that the board of directors, they are responsible for suggesting restructuring measures in case they have this situation of the how do you call it, Unterbilanz, isn't it? So I was wondering if they do that, they propose some measures and then the shareholders do not act, they just don't resolve on any of these proposed measures. Does the board of directors, do they have other obligations in order not to become liable? Do they need to, give up their mandate and say we can't bear this any longer? Or is it sufficient if they have proposed these measures?
Yes, the most important part is that they actually propose it, that they do suggest those restructuring measures. If then the shareholders, the general meeting doesn't want to implement those proposed restructuring measures, then in a first step or in a first stage, the board is not cannot be held responsible. But obviously, if then it continues and then the board, if the shareholders reject the proposed restructuring measures, and then the risk of over-indebtedness rises and actually is imminent, is here, then the second stage applies, and the board of directors then has to, if then the board of directors see, okay, now we really have, we are over indebted, then it must file bankruptcy if it cannot find, or if the other two solutions are not possible.
Okay, thank you. But does this special COVID measure that was introduced now, that you're not liable if you, had a clean balance sheet by the end of 2019 and you have the possibility of restructuring, as long as this is there, there is no liability. But as you mentioned, what happens if the company becomes over-indebted? Then you need to react. Is that correct? Or does this special legislation regarding COVID give you some other opportunities?
No, that means even if you are now over indebted and according to the law, you would have to apply for bankruptcy. If you at the end of last year were not over indebted and you believe, or you have reason to believe that you can recover again by the end of the year, you don't need to file for bankruptcy at this moment.
Okay, so this is certainly helpful. I don't think we have any other questions. So everything seems clear. I think it's a very good opportunity to have you here and to ask questions, but if everything is clear, I think we will continue with our next speakers. And I would like to thank you very much, Lukas. This has been very interesting and very comprehensive, and we really see that there are in fact differences under this special situation today. Thank you very much. So we will continue with our next topic, which now is in fact the unfortunate situation of debt enforcement and bankruptcy proceedings. I remember that famous lawyers, they always said, if this law is not there, there's no real law, because if down the road you can't enforce or do bankruptcy proceedings, any other laws, they do not really help us. So this should be then the most crucial law, actually. Please, Florian, May-Si Hau, I would like to hand over to you now.
So thank you very much, Esther. Hi, everyone. We would like to welcome you to our presentation on debt enforcement and bankruptcy proceedings in Switzerland and China. My name is, as Esther said, Florian Müller. I'm the head of the China desk of MLL. And this is my esteemed colleague, May-Si Hau, senior associate and as well team of our China desk.
Hi, everyone. So before we go into details in these four topics, we would like to say a few words about how you should get prepared for enforcement. So Florian, what are the measures we can take in advance in order to prevent bad debt?
It is definitely much better to prevent bad debt in advance instead of collecting international receivables later, either in Switzerland or in a foreign country like China. Therefore, you should always try your best to investigate the credit status of your trade partner before you sign contracts, deliver goods, or make remittance. For general and financial information on Chinese companies, the National Enterprise Credit Information Publicity System can be consulted.
And similarly, in Switzerland, you may request an excerpt of enforcement proceedings from the Debt Enforcement Office. You need to ensure to address your request to the office where the individual is domiciled or where the company has its registered seat.
Furthermore, it is in general recommended to only do business with unknown Chinese companies or individuals after getting a substantial payment upfront. Having requested such a large upfront payment works both to prove good faith by the Chinese party and to prove that the Chinese party is able to make large payments outside of China.
And if you are already confronted with bad debt?
If you're confronted with bad debts, you should take actions as soon as possible. Due to the fact that lawyer and court fees in China are not cheap and procedures of international commercial cases may last 1 to 2 years, you should first consider negotiation with the debtor to achieve a compromise. In particular, if the facts of the cases are not clear or you lack of evidence. Furthermore, filing a lawsuit will certainly affect your relationship with the counterpart in a negative way and may have an influence on your standing in the industry in general. Therefore, litigation and arbitration should only be initiated after careful consideration.
That makes sense. So property restructuring is always a good way to go. In Switzerland, even though a majority of pecuniary claims can be handled in less than a year, the judicial proceedings of a complex case like a commercial and international dispute may last several years. So what do I have to consider then if I would like to take legal actions?
Should you decide to take legal actions, you first need to check the dispute resolution clause in your contract. If there exists an arbitration clause, you have to submit the case to the agreed arbitral tribunal. If you have non-arbitration clause, you can initiate litigation proceeding against the debtor according to the jurisdiction clause, if you have any. So tell us, May-Si, how does debt enforcement in Switzerland work?
So in Switzerland, debt enforcement and bankruptcy proceedings are governed by the debt enforcement and bankruptcy law. So it applies for the execution of any pecuniary claims. For the enforcement of unsecured claims, there are two types of execution. The first type is the special execution. This leads to the seizure and the realization of the assets of the debtor to the extent necessary to cover the claim for a specific creditor only. The other type is the general execution, namely the bankruptcy proceedings. And all bankrupt assets of the debtor form a bankrupt estate over which the debtor is no longer entitled to dispose. The bankrupt estate will serve all creditors. The choice between the seizure and the bankruptcy proceedings depend on the debtor. If the debtor is a corporation or a limited liability company, so registered with the commercial registry, then the bankruptcy proceedings apply. Otherwise, the rule on the seizure applies for individuals who are not registered with the commercial registry. Besides the bankruptcy proceedings, there is a possibility to enforce a secured claim in the form of the realization of collaterals. If a creditor initiates an enforcement of an unsecured claims against the debtor may request that the creditor exercises his right on the collateral first.
Interesting to note is the possibility of a freezing order.
Indeed, if you have a claim against a foreign entity which has identified assets like a bank account in Switzerland, and if the claim is supported by a certificate of shortfall or an enforceable judgment, you should contemplate requesting a freezing order. The aim is to prevent the debtor from disposing his assets. So now I want to focus on the preliminary enforcement proceedings in Switzerland.
So May-Si, what is the very first step of the preliminary enforcement proceedings?
So the very first step for the creditor is to file the enforcement request with the debt enforcement office. Anyone can file an enforcement request against anybody. The claimed amount shall be mentioned in capital and with interest, as well as with the ground of the debt. Once the debt enforcement office has received such enforcement request, it will issue a payment order, which is a summons to pay. At this stage, the creditor has not yet justified his claim. During the pandemic, the Swiss Federal Council ordered a temporary stay of the debt enforcement proceedings. So no debt enforcement action could be taken against the debtor. This temporary stay still applies to travel agencies.
What happens after the debt enforcement office has issued the payment order?
So after the debtor has been notified with the payment order, he has three possibilities. First, the debtor may directly pay the debt, which is rare. Most of the time, the debtor will file an objection. He can do it directly when receiving the payment order. Otherwise, the debtor can file an objection with the debt enforcement office within 10 days. The objection can be in total or in part of the claim. The third possibility is when the debtor does nothing and accepts the payment order. In this case, the enforcement proceedings will continue by way of seizure or of bankruptcy proceedings.
May-Si, could you explain further what happens if the debtor files an objection?
So if the debtor files an objection, the creditor has three possibilities. If the creditor has a definitive title of removal, like an enforceable judgment or an arbitration award against the debtor, the creditor can apply for the definitive removal of the objection. So if the court accepts the removal, the objection is definitively set aside, which confirms the existence of the claim. Hence, the enforcement proceedings will continue either by way of seizure or of bankruptcy proceedings. On the contrary, if the court denies the removal of the objection, then the enforcement proceedings are discontinued. The second possibility is when the creditor has a provisional title of removal, like a written acknowledgement of debt signed by the debtor, or an agreement with the related invoices. So what we need here is a very clear situation with written evidence. Now, in this case, the creditor can apply for the provisional removal of the objection. The request of provisional removal shall be submitted within 1 year as of the notification of the payment order. If the court denies the provisional removal of the objection, then the enforcement proceedings are discontinued. On the contrary,
come in here? I have a question. This sounds very interesting. If I have this evidence, I can just do and enforce. But what would this evidence be? What do I need to show then that I have?
so I said if you have a written acknowledgement of the debtor, if you have a signed contract and the invoices.
So is this a high level of evidence you need to provide, or is this very easy to do? Because this seems quite, straightforward and easy solution.
This is actually the summary judicial proceedings. So it's quite an expedite proceedings based on written evidence. If you are not able to prove your claim based on this evidence, then you would have what we said here, the action for the lifting of the debt, where it will be on the standard ordinary proceedings. And here, if you don't have, for instance, the written evidence, you can have, for instance, witnesses who can testify about, for instance, how the negotiations were with the counterpart, and go with the full ordinary proceedings with court.
Okay, thank you, and sorry for just dropping in.
No, you're just above one head of my paragraph. Well, that's fine. So this is the action. What I was saying is this is the action for the recognition of the claim, which shall be done within 1 year as of the notification of the payment order. So if the creditor has no title of removal, so he cannot do either by the summary proceedings of definitive or provisional removal, the creditor shall file a civil action for the recognition of the claim in order to confirm the existence of the claim and to set aside the debtor objection. The creditor has also 1 year to submit such a request. Here it's the same. If the existence of the claim is recognized, then the objection is removed and the enforcement proceedings continue. If the creditor fails to comply with the deadline or the court denies the claim, the enforcement proceedings elapse and the action is definitively removed. So now let's see how it is working in China.
So Contrary to Switzerland, in which debt collection office is handling the collection of debt, the procedure of debt collection in China in general always involves the action of a court.
So would you always recommend sending a demand letter to the debtor as a first step?
So for those who don't know, a demand letter is a letter from the creditor to the debtor detailing the debt and demanding immediate payment on the threat of legal action. Although sending demand letters to the Chinese debtor often makes sense in order to notify the default, if such notification is required based on the underlying contract, of course, it is often a waste of time. However, although most Chinese parties ignore demand letters, there is a chance of success if it is done properly.
Now, if you want to initiate an action in front of a court, is there a special regime for simple disputes in China?
Yes, in very simple debt disputes, a creditor may apply to the competent court for a repayment order against the debtor. To initiate the procedure for hastening debt recovery, the following conditions have to be fulfilled: the payment of a pecuniary debt or recovery of negotiable instruments. There are no other debt disputes between the creditor and the debtor, and the order of payment can be served on the debtor. If the facts are clear and legitimate, the court issues a payment order to the debtor within 15 days. Thereafter, the debtor has 15 days to clear off the debt or submit a dissent in writing to the People's Court. Otherwise, the creditor may apply to the court for enforcement. If, on the other hand, the repayment order is invalidated based on the objection of the debtor, the litigation procedure has to be initiated.
And what if you are not able to apply for a repayment order?
For creditors that are not able to apply for repayment order, a civil litigation, or in case of an arbitration agreement, an arbitration must be initiated and conducted before the creditor may apply for enforcement of the debt based on the favorable decision. In China, a case is generally heard by 2 instances. After the first instance judgment, each party can in general appeal the decision in the competent court of the higher level.
And is property preservation an option?
Yes, during or even before the proceedings, the creditor can apply to the court for property preservation if it may be difficult to enforce a judgment or any other damage may be caused to the creditor in case the property is not preserved. The court may order the creditor to provide security to take a preservative measure. The procedure can take place ex parte. Upon granting of the property preservation, the corresponding assets of the debtor will be seized to ensure the enforcement of a decision.
The question for you, how important is evidence in such procedure?
In practice, debt collection procedures rely heavily on documentary evidence. Having the right documents in the right form is therefore crucial. Important for a party is in particular to be able to write the documents in original form and not only photocopies.
And assuming that a debt was affirmed by a judgment, what are the next steps?
After a debt was affirmed by a judgment of the court, the creditor may apply for the actual enforcement if the debtor still refuses to comply with the judgment. The time limit for application for enforcement is 2 years. Based on such an application, the competent court will issue an enforcement notice. Enforcement will then be conducted by an enforcement officer. Measures of enforcement can in particular be to ask the debtor for a report on its property status, to inquire and transfer the deposits, stocks and other property of the debtor in banks, to withhold or withdraw part of the income of the debtor, or to seize, execute or sell the debtor's property.
And how about recognition and enforcement of a foreign judgment?
With respect to recognition and enforcement of a foreign judgment, the competent court will recognize the validity of the judgment and execute the writ of enforcement to execute it after examining the applicable international treaties or the principle of reciprocity and concluding that the foreign judgment does not violate the basic principles of law of the PRC or the interest of the state sovereignty, security, and social and public interest.
Now tell me, Florian, may I ask something? Because this is what
you're really quick, Esther, actually.
So what do we do with the commercial court order from the Zurich Commercial Court? Can we get that enforced in China? And the second question would be your experience in, enforcing in judicial procedures in China. What are the chances of success for foreign investors or foreign partners in a contract?
Yes, you're again really fast, because I was just going to speak about that point. Let me first finish, and when you still have questions, then I'm happy to answer.
I just thought because it sounds very interesting.
Yes. So the rulings of foreign courts are therefore rarely enforced in China. That's our experience. Agreeing on the jurisdiction of or choosing a foreign court for civil disputes is hence in general not advisable from our experience. The better alternative is to agree on international arbitration, where enforcement of the award can be requested based on the New York Convention.
Oh.
Does that answer your question, Esther?
I mean, in real practice, I know the New York Convention. What is the experience in practice? Because that's what people always ask, and I think it's a very hard answer, and there are no real statistics. But I mean, do you have any sort of, are there any figures? Are there any official figures or figures from experiences from, working in China?
I mean, I don't know any official figures, but what we experience is that we have clients that are looking for assistance. We first look into the contract and look into the dispute resolution clause, what they have. And if there is a clause for a court jurisdiction in Switzerland under Swiss law, and the counterparty is Chinese, we say it's really hard to enforce that in China. So we do not recommend. That's something that we would actually never put in a contract. So either you decide for arbitration and then you enforce it, or you decide for jurisdiction in China in a contract written in Chinese, and then you enforce it directly in China. That's another option. But we do never recommend parties to use Swiss jurisdiction with a Chinese party based on Swiss law.
Because you don't have a bilateral agreement. But
Yes.
Would you recommend using a local Chinese court, or would you always go for arbitration? And if for arbitration, what are the most suitable arbitration regulations or venues?
Yes, I mean, you can go for a Chinese local court as well. That's possible, but you have to take the court of the seat of the company. I think that's important. And I think for us, CIETAC is an option, but sometimes it's not for the Swiss client. So it's either Hong Kong or Singapore. I think that's the possibilities. It's often a question of agreement between the parties. They often don't want to have the arbitration in China or in Switzerland, so they look for a further venue.
Yeah. Okay, sorry for dropping in.
No, you're welcome.
Please.
You're the leader of the webinar, so that's always fine for us. Now back to you, May-Si. We're all curious to hear about bankruptcy proceedings in Switzerland.
So let's continue then. If the bankruptcy proceedings applies as continuation of the enforcement, then the bankruptcy office shall immediately notify a bankruptcy warning to the debtor. And if the debtor still does not pay the debt, the creditor has 20 days as of the notification of the bankruptcy warning to request to open the bankruptcy proceedings, so with the competent bankruptcy court. The court will declare the debtor bankrupt at a specific point of time. And from this moment, all seizable assets of the debtor become the bankrupt assets, so for all creditors.
The bankruptcy court may obviously also reject the requests as well, May-Si. What about adjournment of bankruptcy proceedings?
So the debtor can request the adjournment of proceedings, even though the requirements for bankruptcy are met, when the moratorium, which is a kind of agreement with the creditor, is possible. It belongs to the debtor to submit such request before the bankruptcy hearing. The debtor shall normally submit a restructuring plan, but currently it is not required to submit such a restructuring plan. This is actually one of the measures taken by the Swiss Federal Council due to the pandemic situation. So the Federal Council has published an ordinance in order to prevent bankruptcies. So this is the COVID-19 ordinance on insolvency law. It is valid from the April this year, and it is applicable for a period of 6 months. One thing interesting to note in this context is the COVID-19 moratorium. So this COVID-19 moratorium applies to SMEs that were not indebted on the 31st December 2019, or that they have subordination letters from the debts. And second condition, they are not subject to ordinary review. The debtor has to support the request by presenting its financial situation in writing. This moratorium, so this COVID-19 moratorium, applies to debt existing before the moratorium, except for the first class claims like salaries. And the main effect is that no enforcement proceedings can be initiated or pursued during the moratorium for such debt. The debtor is not entitled to pay such debt as well, but he is allowed to continue his activity.
What about bankruptcy proceedings that begin without preliminary enforcement proceedings, May-Si?
So there are indeed 5 cases in which bankruptcy proceedings can be initiated without preliminary enforcement proceedings. So the debtor can obviously request a bankruptcy for himself, but these proceedings apply most of the case when the company is over-indebted, as it was mentioned before. So the board of directors of the company has a duty to notify the bankruptcy judge about the company's over-indebtedness. So here again, with this COVID-19 ordinance, there is a suspension of the duty to notify the judge about the company over-indebtedness. And as said before, and I would like to repeat the requirements here, the company do not have to be over-indebted on the 31st December 2019. And what's important is that the company can be remedied of its over-indebtedness before the end of the year.
Let's assume that the requirements for the suspension are met and that we have to pursue with the bankruptcy liquidation proceedings. How do we choose which liquidation proceeding applies?
So the choice of the liquidation proceedings is made on the basis of the inventory established by the bankruptcy office. So if it is obvious that the assets are not sufficient, then the bankruptcy proceedings is suspended due to the absence of assets. If inventoried assets exist but are not sufficient to cover the fees of the ordinary proceedings, then the summary liquidation proceedings apply. So this corresponds to a large majority of cases. If the bankrupt debtor has sufficient assets to cover the fees of the liquidation proceedings, then we have the ordinary liquidation proceedings.
Let's have now a quick overview of the ordinary liquidation proceedings then.
So with the publication of the bankruptcy proceedings, the bankruptcy office will proceed with the call to the creditors, inviting them to produce the claim within 1 month. The bankruptcy office will also summon the debtor and anyone who have or may have assets belonging to the debtor. At the same time, the bankruptcy office will also call the first creditors meeting. The purpose is to decide on the organization of the proceedings, namely to appoint the bankruptcy administration and eventually the supervisory commission. So this meeting may also allow the bankrupt entity to continue its activity. Then once the creditor have submitted the claims, a schedule of accepted claims can be prepared and the bankruptcy administration shall be able to establish all the assets and liabilities of the debtor. And quickly after that, the second creditors meeting takes place with all creditors whose claims have not been definitively rejected. The purpose is one, to decide on a proposal on insolvency, concordat. Second, to confirm the election of the bankruptcy administration and to the supervisory commission on the basis of a liquidation report. And third, to take any action relating to the bankruptcy assets and their realization. So the bankruptcy office can establish the distribution plan, which allows the distribution of the remaining and available assets among all the creditors. The creditors would receive a certificate of loss if they cannot fully recover the claim. And once the bankruptcy proceedings are closed, the bankrupt company, so the debtor, will be struck off the commercial register. So now, Florian, tell us about bankruptcy proceedings in China. Who can be subject to bankruptcy proceedings there?
So the PRC bankruptcy law applies to all types of legal person enterprises incorporated in China. Generally, the bankruptcy law adopts many concepts known in Switzerland. However, there is no concept of a personal bankruptcy.
So that's different from Switzerland. And are there also various forms of insolvency procedures in China?
Yes, under the PRC bankruptcy law, there are 3 insolvency procedures: the bankruptcy liquidation, the reorganization, and the compromise arrangement. The purpose of the bankruptcy liquidation is to liquidate the debtor enterprise and to distribute its assets to the debtors, to the creditors and the shareholders. The purpose of the reorganization is to allow the debtor enterprise to continue operating its business under the supervision of an administrator, suspend the creditors to enforce their right on a temporary basis, and enable creditors to obtain payment from the reorganized debtor enterprise. Last but not least, the purpose of the compromise arrangement is to allow the debtor enterprise to rescue itself from liquidation through a discounted payment.
I see. That is, on the other hand, similar to Switzerland. I don't think we would have the time to go into detail to all procedures, so let's only focus on the bankruptcy liquidation. What are the requirements to initiate the bankruptcy liquidation?
The requirements to initiate the bankruptcy liquidation are that a debtor enterprise cannot repay its debt that have fallen due, and 2, its assets are insufficient to pay all its debts, or it manifestly lacks the ability to repay its debts. The applicants for the bankruptcy liquidation can either be the creditor of the debtor enterprise or the debtor enterprise itself.
Interesting. And does the procedure for bankruptcy, and how does procedure for bankruptcy petition look like?
As just mentioned, the application for the bankruptcy liquidation is either made by a creditor or the debtor enterprise itself. Thereafter, the court issues the ruling under the consideration of the debtor enterprise objection, if there is any. Bankruptcy cases are subject to jurisdiction of the court in the place where the debtor enterprise is registered. The court will lead the whole bankruptcy proceeding. The acceptance of the bankruptcy petition by the court imposes an automatic stay on any legal actions and suits. Furthermore, any individual settlement made after the court has accepted the bankruptcy petition between the debtor enterprise and the creditor shall be void. After the acceptance of the bankruptcy petition, the debtor enterprise has in particular to submit to the court an inventory of assets and debts, and the court notifies known creditors and makes a public announcement. Thereafter, the creditors have a period between 30 and 90 days to submit their claims. After the expiry of this period, the first creditors meeting takes place.
So what is this first creditors meeting for, and what happens next?
The creditors meeting is that place where the creditors exercise their rights and express their opinions. The creditors meeting is comprised of all creditors who have filed their claims, representatives of employees, and the debtor enterprise's labor union. The power of the creditors meeting includes in particular the verification of claims and the adoption of plans for the distribution of the bankrupt assets. Each creditor is entitled to vote in the creditors meeting, where resolutions are in generally passed by more than half of the creditors present at the meeting, who hold no less than half of the total unsecured assets. During the bankruptcy proceedings, the administrator, who is appointed by the court, is responsible for the management of the debtor enterprise's assets and business. The administrator first submits the proposal to convert the assets into cash and thereafter the distribution plan to the creditors' meeting, which will decide thereupon. After confirmation by the creditors' meeting, the distribution plan has as well to be submitted to the court, which can as well decide in an early stage in case a final rejection by the creditors' meeting has taken place earlier. Upon approval by the court, the administrator implements the distribution plan and makes a public announcement. Finally, the court rules on the termination of the bankruptcy procedure and the debtor enterprise will be deregistered. On the other hand, in case a debtor enterprise or a third party fully repays or provides security for all due debts, or the debtor enterprise has no assets to be distributed, or its assets are not sufficient to pay the bankruptcy expenses, the liquidation procedure is directly terminated.
Good to know. Thank you, Florian. So we are at the end of our presentation. So if you have any further questions, don't hesitate to ask them now or send us later on. So Esther, do we have any questions?
No, everything seemed to be so clear. You made it so clear. Obviously, there are no questions, neither back to Lukas, so no chats, no nothing. So I think this was really comprehensive. So I would like to thank you very, very much. And also, of course, to the attendants, I would like to let you know what our next seminar is all about. We go now in a summer break. I think everyone deserves it now after this long period of COVID back home and a lot of webinars and working from the home office. But please note down our next seminar. It's August 27, the same time, same setup. We will move towards China now, more on the China side. Giving opportunities. China provides now post-COVID measures that try to treat foreign enterprises better, to help them. And we will look at investments and at trade measures where Swiss companies or foreign companies can be privileged if they follow these measures. So I think this will be a very interesting session again. And I would like to thank everyone here, particularly our three speakers who have done an excellent job. And I would like to thank Beilun, whom we can't see, but she's always in the background managing everything. And I would like to thank all the attendants for having been here. And I wish you all a very nice and good summer. Enjoy the weather and the time, and hopefully without COVID measures any longer, so we can go back to normal. Thank you again and see you next time. Goodbye.
Thank you.
Thank you. Goodbye.
Thank you. Bye.